Honorable former Chief Justice of India, whom I just said looks pretty much the same as when he left us from the Supreme Court. Seems to be no change. A man who conducted himself with least ostentatious and maximum results, and the only Chief Justice of India who appointed on the same day 3 lady judges to the Supreme Court. The Chancellor of this remarkable institution, we had heard of it up north, but seeing the physical scale and size of SRM amazes and never ceases to amaze. And this is only one campus, 5 of these campuses. Truly a visionary, truly a leader who has developed these set of institutions. Esteemed members of the academic community, from the Pro-Chancellor downwards, above all, students who are here at this Center of Learning. Friends, to even try and do partial justice to the topic of reforms in the administration of justice to reduce delays in 25-30 minutes should earn me a Nobel Prize for miniaturization. I will therefore do the job of a fan dancer, touching upon various facets of the subject without really covering it. So let me straight away plunge into it. You know, the field of administration of justice is a field full of paradoxes. In India, we have the highest and the fanciest flights of jurisprudence, the most sophisticated, nuanced doctrines. In the bench and in the bar, the best and the brightest in the world. A vibrant, pulsating democracy, a dynamic legal system, avant-garde doctrines like PIL, like basic structure, judicial review of a scale and magnitude which would make the judges of Marbury and Madison blush. No other place on planet Earth has judicial review of the kind we have here. And yet, the paradox, the sad paradox is that we must hang our head in shame when we turn to the scourge of arrears, backlog, the battle of the bulge, the theme of this address. We have been sermonizing, lecturing, seminaring, talking for the last many decades on this scourge of arrears, pendency, delay, etc. And yet, under our very nose, from the 2018 figure of 3.5 crores, which if you tell any foreigner is shocking enough, from the 2018 figure of 3.3 crores, we are now, and this is a figure 2 years old, July 23, a parliamentary stated figure, of 5.02 crores. Under our very noses, we have climbed the wrong hill and achieved the wrong milestone. How long will we blame COVID? How long will we keep on appointing committees, commissions? My favorite quote about these bodies is what a wag once commented, which I love to repeat. A committee is the group of the unfit, appointed by the unwilling to do the unnecessary. So you can keep on appointing them and getting their reports till the cows come home, but under your noses, the arrears have ballooned from 3.3 crores to 5.02 crores. But when you go into the details, which I'm going to try and do in my 25-30 minutes, you realize Benjamin Franklin's apt phrase, "For want of a horseshoe nail, a kingdom was lost." Many of the panaceas and remedies are very small, practical, nitty-gritty. But unfortunately, we have not applied them consistently. I have been advocating, more particularly, I think, vocally and aggressively after Chief Justice Ramanna left the court, for a common minimum program between successor Chief Justices, a CMP-like political parties. Chief Justices each wants to leave his stamp. So you must first agree to disagree on many issues. But at least on 5, 7, 10 issues, you and the next and the next and the next and the next, all the Chief Justices up to 2032 or 2034 should have a CMP, a common minimum program. Decide those core 5, it doesn't matter what they are, 5, 6, 7 for the benefit of the court, and then uninterruptedly, without zigzag mid-course corrections, follow it. Too often in this country, we change, we modify, we dilute, we do zigzagging, and therefore the efficacious final result of these policies do not translate on the ground. So friends, as I plunge into the details and give you my 10, 12, 15 wish list of changes, let me start with a few preliminary points, completely general and preliminary, but important to keep in mind. First, till recently, and I've been speaking on this subject for over 2 to 3 decades, till recently, reforms in the administration of justice, which includes this whole gamut of delay, backlog, etc., was not a taught subject in law programs across the country. It's quite an amazing thing. You would be taught contract law and constitutional law and tort law and this and that, but you were not taught what they don't teach you at Harvard Law School, how to run the legal system. The nitty-gritty of reforms in the administration of justice. I'm told happily it is now changing, but still slowly. Second, we need far fewer sermons, far fewer lectures, including this one, and much more implementation on the ground. Consistent, continuous, uninterrupted, unchanging implementation. And you'll start seeing the changes. Third, this figure of 5 crores, if you go and attack it properly, to a large extent you will find it's a house of cards. It can be made to collapse with not much difficulty. Fourth, follow Thomas Hardy's dictum, take care of the small things, the big things will take care of themselves. Frequently, we do the reverse. Fifth, have a holistic plan, including the CMP. The holistic plan must be both prophylactic, preventive, as also ex post facto curative. And it must be tied into one holistic plan, not piecemeal, not episodic. And finally, bring in attitudinal change. Attitudinal change has happened in the Supreme Court from the 1990s, where I was personally, as a much younger lawyer, associated with the so-called Ahmadi project. And the Supreme Court remains an island of excellence and exception. It is the many Indias in one syndrome. So the Supreme Court is not a good example when we talk of arrears. But you've had attitudinal change right early on in the 90s, which is why they've managed their arrears much better than the other 2 layers of the Indian judiciary, the high courts and the district judiciary. Well, friends, first, the answers are obvious. They don't require rocket science. They don't require too much of thought. You can't have lovely, fantastic buildings, equipment for hospitals, medical equipment, but no doctors. How are you going to treat patients? You have the same thing in all the grand court buildings will amount to nothing when, just a simple statistic, at no point of time after independence, that is 78, 79 years ago, at no point of time have more than 2/3 of the entire High Court judiciary of 1100 odd been filled. So at any point of time, 1/3 is vacant. 300 odd, 330, sometimes more. I'm giving an average. At no time has more than 3/4 of the lower judiciary, the district judiciary, been filled. That's roughly 25,000 odd. 1/4 is always vacant. How can you talk of arrears? If your sanctioned strength is not filled, all these sermons are empty. unless you fill them. How you fill them is your problem, but you have to fill them. Second, if you closely analyze these arrears, more than 5 years old are only 25% cases. This is another surprise. Out of 5 crore odd cases, more than 5 years pendency is only 25, 1/4. You must straight away in every court across the country, each district court, each civil court, each high court. Supreme Court doesn't really need it that much. Start a second track. One track which deals with filings and disposal, the traditional track, but a separate track of judges which ensures dealing with these above 5-year 25% cases. They will vanish in a few years. Many of them are infructuous. Many of them are just numbers on a piece of paper. Nobody has tracked them. And imagine when you get up in the morning and you read that there's a 40-year-old case in X High Court, there's a 35-year-old case these are stray cases in Calcutta High Court. If you attack these 25% out of the 5 crores, more than 5 years old, you can pretty much get rid of them on a second separate track which only deals with them. Something as simple as I said, everything I say will be mostly utter, banal common sense. Occasionally you might think it is uncommon nonsense, but usually it is only common sense which is required. Let's turn now to the further ABCD, the access for A, backlog for B, C for costs, and D for delay. The ABCD of this system. This issue of vacancies, 33% in the High Court, 25% in the lower judiciary. You know, a chap called a professor in London School of Economics called J.A.G. Griffiths wrote a delightful penguin book in 1960s called The Politics of the Judiciary. When he wrote that book, there was a huge uproar in a conservative country like England. How the hell can you use a phrase called politics of the judiciary? Our appointment process today would make the 1960s Englishman and J.G. Griffiths blush. Why do we have this 1/3 at the High Court level? If you blindfold any student here who's not a lawyer and send him to all the 28 High Courts across the country, he can tell you in 1 month who are the best 5 or best 10 to be appointed. So selection of the best 5 or 10 is not difficult even by a blindfolded non-lawyer. The problem in our system is that after we know who they are, instead of appointing them, we start disappointing them. That's the problem. And that process of disappointment takes ages. Now we have the figures. Some 33% things may be recommended by the collegium, and I'm not talking politics, I'm not talking government A or government B. But 40% may be pending. Now you made the law. Why don't you implement it? You made the law which says very clearly, 7 judges, 9 judges, a second referral binds the government. Now the percentage of cases pending, re-referred and not appointed after a second reference is still very high. I have publicly, and I repeat it here, many years ago, and I have no hesitation in repeating it, on a second referral, if your appointments are delayed, why have you not issued a single notice of contempt of court? Not to very highest, but maybe to the law secretary. The delay will stop immediately if you do it in 2 cases. But you need to be bold and unconventional to get rid of these. This has gone through a process of first collegium, second collegium, reference back, and a second reference. There's no reason for a second delay. It's just that you don't use the powers which you have yourself written. And this is, by the way, remember, when we have agonizingly climbed from 11 judges per million of Indian population, lowest in the world, to 19% because of Supreme Court stick. But that 19 or 20% is the sanction strength. If 1/3 is vacant, you're actually functioning at 15 or 16 judges per million of Indian population. The figure in US is 50 million per population. The minimum average required for India is 33 judges per million of population. We are not able to fill our 19 judges per million of population. And the funny part is that many years ago we increased the sanction strength of each High Court. by 10%, 20%, 25%. No High Court has even fulfilled its pre-increased sanction strength. So you increase the strength, but you are functioning below the pre-increased sanction strength. Now, friends, as I've already said, you must have a second track to deal with cases more than 5 years old, and you must have fuller complement of judges to deal with the main track of 75%, which are less than 5 years. Fifth, the Supreme Court did me the honor of quoting my article in one of the judgments of the Supreme Court called Lok Prahari. Many years ago, I had written a piece. And I said it's incredible that there is an article in the Constitution of India called 128 for the Supreme Court, and another article inserted in 1963, a parallel one for the High Courts, called 224A for ad hoc judges. Ad hoc judges can be appointed to High Court X once they've retired from X or retired from any other High Court other than X. Do you know that, to the best of my knowledge, not a single High Court ad hoc appointment has been made? The appointments to the Supreme Court have had 3, 4 or 5 in 75 years, ad hoc judges. That too not for the last 20 years. Now the reason I say this is that you fight, you do politics, you disappoint instead of appointing, you delay. That is the time when you can use a category of tried and tested pool of people who have retired. There are a large number of anonymous, hard-working, decent judges whom you don't need to test again because they pass through the system. They are retired. Why don't you appoint those as ad hoc till you fight over your appointments and not have 1/3 of High Court vacant? Sixth, Swaminathan Iyer, a very renowned economist, did some statistical survey and wrote some 4 or 5 years ago. I don't quite accept his figures. I think he's too optimistic. But he, on the lower side, said that only 2,200 judges in lower courts would virtually clear all the, 2,200 additional judges in the lower courts would virtually clear the arrears. And 100 to 150 additional in the High Court. Supreme Court, anyway, I don't think is a real problem. Why can't we do this? This is not anything great. We talk about going to the moon, we talk about space, we talk about deep sea underwater diving. This is not a big thing. That's why I said, for want of a horseshoe nail, a kingdom was lost. Take care of the small things, the big things will take care of themselves. Then, it is not a question, it's also a question of assessing the speed. You must remember, the power of technology is the power of information sharing. The power of information sharing is the power of awareness. And the power of awareness is the power of embarrassment also. Why does the High Court, every High Court and indeed every district court, every month, not publish a performance assessment report of each judge? You are not trying to deliberately embarrass a person. A magistrate, a senior magistrate in the 1960s in Delhi did that. And the entire approach changes by the fact that people realize that they are being assessed and their figures are published in terms of dealing with cases. You can do it without comment, but use the power of information to do performance assessment and publish the figures. It carries with it an inbuilt power of embarrassment and therefore of greater achievement if you are sensitive to criticism. Of course, it goes without saying, as my 8th point, it's not about numbers alone. It's very much about quality. It's no point appointing a horse in the place of a goat, or a goat in the place of a horse for that matter. And one bad appointment people don't realize is something you suffer for at least 10 to 15 years, and it spawns a progeny of hundreds of cases wrongly decided. All this ABCD, access, backlog, cost and delay, was very well put by Palkiwala more than 30 years ago, who said then, I just quote him, "May I turn now to the situation in India, which has the second largest number of lawyers in the world. After US, we still have the second largest. While it is true that justice should be blind, in our country it is also lame. it barely manages to hobble along. The law may or may not be an ass, but in India it is certainly a snail. It moves at a pace which would be regarded as unduly slow in a community of snails. A lawsuit once started in India is the nearest thing to eternal life ever seen on this earth. Some have said that litigation in India is a form of fairly harmless entertainment. But if so, it seems to be a very expensive way of keeping the citizenry amused. That is sarcastic, that is caustic, that is scathing, but it is completely true. Let's look at, as a ninth point, ADR. Actually, ADR is broadly four things: arbitration, mediation and conciliation I treat as one, Lok Adalat, a little bit of sprinkling of Gram Nyayalayas. Arbitration, unfortunately, has largely failed because it has become very aptly called pre-litigation litigation. It is an additional rung for lawyers to have fun at and for judges to scream at arrears, because it is full pre-litigation and then the real litigation starts after the award. Gram Nyayalayas have hardly taken off in number terms. The real success story, if you look purely at numbers, is Lok Adalats. And that has now done the fantastic figure, I am told, in May 2023 of almost 21 crore disposals. That is 200 million plus disposals. That is an achievement, but we all know the limitation of Lok Adalats. Petty claims, land acquisition, motor vehicle accident, etc., etc. It doesn't apply to a lot of other categories. Where comes the fourth area? And today, India, from September 23 onwards, has a world-class, truly a world-class Mediation Act, a new act, state-of-the-art. And this is the time, we don't have figures available for it, indeed for arbitration or mediation, as we do for Lok Adalats. But this is the time to move up the ladder and get the best results in mediation and conciliation with this act. For corporate matters, for high-stakes matters, for medium matters, for diverse matters. I don't have time. I spoke in USA at Pepperdine University, the home, the Mecca of mediation, on this new act. I don't have time to do that now, but if you look at it, you will see that it has all the infrastructure and concepts which are required. It's only that the Indian genius of judges and lawyers have to put it to good use. Friends, the next point is about, and as you can see, I am following my self-imposed limitation of being a fan dancer, touching upon topics without really covering them. Delayed justice must also be seen as the most egregious and unpardonable form of human rights violations. There cannot be a worse form of human right violation, because delayed justice applies as much to criminal as to civil. There are 6 lakh under trials languishing for more than 5 years, 7 years in jails. The jails are supposed to have, in many cases, of course, 4 times the occupancy, but on an average, twice the permitted occupancy, on an average. I have the details, but don't have the time to give you the state-wise breakup. We have never, you'll be astonished how petty we are. Bail, something like bail, has 81 types of filing and registration in all the high courts put together. Different names, different nomenclatures, different styles. So you can't even do a comparative survey. You'll be even more surprised that although happily I am told the average disposal time for bails is only 23 days. But there are states like Jammu and Kashmir where it is the average time is 156 days. We're talking about bail applications. Odisha was 61 days, Mumbai was 56 days. These are about 2-year-old figures, 1.5 years old figures. We have not experimented with new ideas, for example, like GPS-enabled anklets. A large number of under trials and people behind bars don't need to be there. You achieve exactly the same result of flight risk, tampering, etc. by GPS anklets, which countries less developed than us are using effectively. That's why I said you need to think out of the box and take these bold steps. As Chief Justice Ramanna said, it is certainly not the judiciary alone, and I'm not blaming the judiciary at all by itself. There is a failure in every sector, every segment, every organ. Take, for example, the government, the biggest litigant. We don't know it's 60%, somebody says it's 70%, it is at least 50% of the litigant in every matter, possibly 60, 65. There are every few months, or every few years rather, a litigation policy published by the government. The litigation policy gives you long, big sermons. Just a few years ago, I had a remarkable experience and I told the Supreme Court arguing a matter. Some litigation policy came a week before my matter reached the Supreme Court, or 2 weeks before, which said that if the government loses an award, which includes public sectors, 75% of the award amount must be paid and then the government must appeal. Because they found a large number of companies with award in their favors who were going to IBC because they didn't get the cash. Because the government would challenge and the matter would languish. 2 weeks after that, no less than the Attorney General appeared asking for a 100% stay. So I pointed out the litigation policy of the Government of India. They said, but that may be different. This is an individual case. So nobody follows these litigation policies. I had the privilege of serving as Additional Solicitor General in 1997. And I became an expert in 6 months on reading between the lines as to why a file has come to me to get approval to file an appeal, or why it is done for getting my stamp of approval for not filing an appeal. Because the officer wants to save his backside. So we need to have actual people on the ground with broad shoulders or shoulders broad enough to implement these litigation policies, which come every 1 or 2 years and are thrown into the dustbin. Ultimately, don't forget, friends, it affects not only human rights. The biggest crime becomes poverty, not the crime you're accused of. They suffer the most. But at the other end, it affects business efficacy, commercial efficiency, predictability, closure, stability, certainty. It is the antithesis of a desirable business environment. I have a chart here which shows another malaise. Delays, as I said, are caused by multiple things, not one. And this delay which I'm going to tell you about now is something we don't even notice. You know, an important issue of law, actually by reference and re-reference from a division bench to a 3-judge bench, from a 3 to a 5, and sometimes from a 5 to a 7, takes 10 to 12 years to travel. Lalita Kumari, a case we all know about the registration of an FIR, travelled from 2008 division bench to 2012 5-judge bench and finally got decided in 2014. Now the law is settled in 2014, but the law was settled earlier in Lalita Kumari on 2008. Between 8 and 14, 6 years, the poor high courts must have spawned a progeny of at least 1,000 cases following the 2008 judgment, or being confused whether to follow the 2008 or the later 3-judge reference. This is how we create litigation. It has happened in many cases on the reinterpretation and the comprehensive judgment on 319. Hardeep Singh starts somewhere in 2008, ends up in 2014, same years again. Subramaniam Swamy on the issue of prior central government approval in criminal law starts in 2005 and ultimately gains certainty in 2014. In between, you have a huge number of high courts and district courts struggling with the uncertainty of law, and that's a huge arrears addition which we don't even notice. Friends, I'm going to finish shortly, but I'm going to be a little bit above time, about 5 minutes more. There are, of course, good things happening. But the good things are happening, as I said, because there is a syndrome of many Indias in one. India is never one, many Indias in one. Supreme Court is a different India, and the high courts and the district courts are a different India. In Supreme Court, we have had recently a lot of things happening. It's the heaviest apex court in the world. But, you know, over 1 lakh or over less than 1 lakh, etc., is nothing compared to the 5 crore cases we are talking about. So really, we shouldn't be spending much time in the Supreme Court, though I must tell you that the recent initiative of dealing only with non-miscellaneous day cases, NMD, reduced a bulk arrears by 4.83%, which is a pretty good figure. The case clearance ratio, which the Supreme Court has decided now, which is more disposal than filings, reached 106%. You've had an accelerated reform in the registry for verification, curing of defects, prompt listing, minimal mentioning or zero mentioning with email mentioning only. And you have involved management techniques like the Center for Research Planning, a Supreme Court research wing, which has a 30-member team which has analyzed 10,000 cases and made down uniformity standards. You know, uniformity is another minor thing. But in India, you have, now of course they say that there should be only 48 categories and 182 subcategories. That's the new norm. But otherwise, across the high courts, you have a bewildering array of different categories. You can't have a computerized assessment at ease. Friends, the criminal justice system, as I said, the crime becomes not the crime you are dealing with, the crime becomes poverty. Apart from 33%, one-third judges in the High Court and one-fourth in the District Court, did you know that at all times 22% in the police forces seats are vacant? 22% in the police forces means 5 lakh seats are vacant. A large number of them are the supervisory, technical and senior positions, because the constable level has 80% occupancy. But the vacancy in the higher levels is 35%. You have a shortage of one-third, 33% in prison staff. You have a jail overcrowding in the last 10 years has increased from 18 to 30%. I'm not trying to just throw figures at you. The figures are not important, the message is. The underlying message is clear that how do you solve crime? How do you deal with crime and delays and backlog? And remember, 90% of this, probably 95% of this, affects the poor and the marginalized. That's why I said those behind bars in that category are not really guilty of the crime they've committed, but they are guilty of the crime of poverty, which is something, as they said, our courts are like fine wine. Some can say that they improve with age. But honestly, justice delayed for decades can rarely taste sweet like wine. The Daksh, a Bangalore research project, has shown that 55 to 60% of all times of the lower judiciary is spent in doing routine work on a particular day, administrative routine work. That is over half, that is 60%, that is like issuing summons, giving dates, no substantive work is done by 60%. Each court has about 90 cases on an average adjourned every day, 90. 50% of district courts have no VC on their desk, enabled and functioning. In many states, the shortage of judicial staff is 50%, but the average is 27%. I mean, I could keep on giving you shocking figures. None of these requires any great study or rocket science or genius. It requires hard-nosed, nitty-gritty implementation. So friends, as I end, let me say that the health of a democracy is not measured by the grandeur of its courts, and we have some very, very grand buildings, but by the speed and fairness with which justice reaches its people. We have to change our entire perspective and follow Gandhiji's dictum, customer is king. This system is not for you, the potential lawyer, me, the current lawyer, or him, the judge. This system is for that customer, the litigant. Gandhiji called him customer is king. That perspective has to change. The litigant, more often than not, that customer wails. He says, दोपहर तक बिक गया बाजार का हर एक झूठ, दोपहर तक बिक गया बाजार का हर एक झूठ, और मैं एक सच को लेकर शाम तक बैठा रहा. Every case resolved promptly is a reaffirmation that the law exists for citizens and not the other way around, that the citizens exist for the law. if we do not pull up our socks, indeed our shoes and legs, we are going to suffer from Iqbal's famous and unforgettable words about the unpardonable sin. He said, एक ख्वाब ऐसा देखा था ताउम्र नींद आई, एक ख्वाब ऐसा देखा था ताउम्र नींद आई, लम्हों ने खता की थी, सदियों ने सजा पाई. Thank you very much.